morning, everybody. Thank you for joining us for our board member liability webinar in collaboration with Siegfried Rivera. My name is Barbara Alvarez-Sanabria, and I have been with Vesta since 2013, and I provide property management services throughout the state of Florida. As a company, we have over 800 associations and 16 offices throughout the state. So thank you, and looking forward to having a very good conversation with everybody.
Good morning, everyone. I'm Caridad Rusconi. I'm a shareholder at Siegfried Rivera. I've been with the firm since 2005, and I concentrate my practice in community association representation. Our law firm sends 600 associations, and we can handle every aspect of associations' needs, from construction defect claims to general practice, meeting packages, amendments, real estate transactions. From A through Z, we can handle all needs for all associations. But with that, thank you so much for joining us today. As Barbara mentioned, we're here to discuss whether board members can be sued. And unfortunately, the answer is yes. As we all know, in the United States, anyone can get sued by anyone for anything and at any time. But board members in particular are often exposed to greater liability because of their roles as members of the board of associations. Now, in the next slide, we're going to discuss some of the reasons why board members get sued. What are the usual pitfalls? And this is where Barbara and I will share some of our experiences on these topics. So as you can see on the list, we have failure to maintain common elements. As we know, board members have a fiduciary responsibility to comply not only with statutes, but also with their governing documents with regards to the maintenance of common elements or common areas for HOAs. And the failure to do so in a timely fashion can expose board members to liability. For example, if in a condo, the roofing system needs to be replaced every 20 years, and the board decides, we're going to extend that to 40 years. But in the meantime, there are numerous leaks, numerous breaches that result to potential damage to units because water penetrates those units and damage personal property or the unit itself. In those cases, board members can be exposed to lawsuits for failure to properly maintain the common elements. Barbara, I'm sure this is something you see a lot.
It is. One of the things that we see a lot, especially in HOAs, is we see the slip and falls, and they're mostly on the sidewalks. So we know that a sidewalk has a lifespan of 40 years. However, if the trees around it are growing and the tree root grows and starts to lift up that sidewalk, you have created a trip hazard. That trip has to be mediated every single year.
Right. Or if, I've had associations where for whatever reason, algae just grows on the surface of the sidewalk, excessive rain, and, there needs to be pressure cleaned every once in a while to avoid slipping. That's also an issue that needs to be addressed. But the one you just mentioned is a really important one, because I see time and time again where sidewalks are cracked or broken or lifted because of root systems. It's very important that those things be addressed as soon as possible, because they do present a trip hazard, and the association is responsible to address those issues as soon as possible.
And those issues are easily addressed.
Right, of course. I mean, unfortunately, everything costs money. And depending on the association, especially nowadays with the pandemic, I know a lot of associations are going through some hard times. Some owners are unable to pay their assessments, or just, have lost their jobs and are not paying their assessments. So associations may be hurting in terms of cash flow, but nevertheless, these things should be at the front burner in terms of taking care of them as soon as possible, because they do expose the association and the board members to potential liability. The next one on the list is inadequate or lack of security. This one always gets a lot of questions because, it does not mean that associations are tasked to secure 100% the health and safety of every unit owner. The association is not the police. The association is not the government. But nevertheless, if the association takes on a responsibility for security, then it must make sure that it adheres to it and follows through with providing that security. So for example, if the association has, this is mostly for HOAs, and some condos have an entry gate system, or a gatehouse, and that prevents people from just being able to walk into the community. But for whatever reason, the gate is just not working. It broke, it was crashed into or whatever. We just cannot allow that gate to remain unoperational for many, several months, because it's a breach. It's a breach of the security. It gives access to everyone, and it's something that people have relied on to provide them an extra layer of security. It doesn't mean you have to fix it within 24 hours, but it does mean that it cannot be something that is left unattended to, or for months and months and months, or made a decision, we're just not going to fix it because it gets broken too many times. That may expose associations, because it is a level of security that owners or residents have come accustomed to. Same thing with security cameras. I have a lot of associations that want to install security cameras everywhere, but then they decide that they're not really going to maintain the security cameras, or they're not going to maintain the footage. Once you take on the responsibility, or you take on a task, you have to make sure you see it through. So those cameras must be operational as much as possible. Obviously things break, but it has to be part of the maintenance routine of the association to make sure that those cameras are operational, that the video recordings are maintained if possible, that they're not being erased. Most of them have a period of time that they're good for, but you have to make sure that the equipment is working properly, just so you're not exposed to inadequate or lack of security claims. Is this something that you see a lot? Where
it is, and one of the other things is how you also put security cameras on a budget. You don't want to put security cameras if you don't have security cameras on your budget, or any type of security service if you're not really providing that service, because that gives a false sense of security to the homeowner.
Absolutely. Absolutely. It's just, if you're going to undertake a responsibility, then you need to see it through. You need to make sure that it's being implemented in the best fashion possible. Remodeling disputes, holiday decoration disputes. The holiday decoration disputes are those that come, these are seasonal issues. Individuals who want to decorate either for religious reasons or just holiday reasons. We have to, most associations do have rules with regard to when holiday decorations can be put up and when they have to be taken down. It's important that those rules be applied across the board, that there be no, if you fail to enforce them and then you try to enforce them against one but not the other, then now you're exposing the association as well as board members to potential liability. Flag restrictions. Again, both the Condo and HOA Act have specific provisions that allow owners to maintain a certain United States flag of a certain size. In homeowners associations, they're even allowed to have a flagpole of no larger than 20 feet. And in certain situations, you're also allowed to have flags for the different armed services, the Army, the Navy, the Marines, the Coast Guards, and the Air Force. So again, these are all statutory provisions that allow homeowners to have a flag during certain times of the year. Now, the big one, probably, for most associations nowadays, especially for condos, pet restrictions. I could tell you that in my practice, like I said, I've been with the firm since 2005. I probably deal with pet issues probably every day of the week. And this is a big issue now with the increased request for reasonable accommodations for what we refer to as assistance animals. Now, assistance animals can be service animals under the Americans with Disabilities Act, which are animals that perform a specific task, like for individuals who are blind or who are quadriplegic, as well as emotional support animals under the Fair Housing Act, which simply provide emotional comfort and support to individuals. Both are equally as protected. Both are equally as important, that the association review every request for reasonable accommodation with care, because it will expose the association to liability for discrimination both as the association and as the board. So when you receive a request, this is especially true for buildings that are no pet buildings. If you receive a request from someone who says that they need a reasonable accommodation to maintain a pet, then it's something that you need to evaluate with your attorneys. For them to evaluate the request, make sure that you're being provided all the necessary information that the association needs in order to be able to properly determine whether the accommodation is one that is needed and is one that you need to comply with. There are certain things that the associations can ask for, but in all, the amount of information associations can request is limited. So you have to be careful. Associations have to be careful that in their quest to obtain information, they don't cross the line between obtaining information and what may be viewed as harassment or an attempt to intimidate the person from withdrawing their request. So this is one of those areas where I always tell my clients, be careful, let your attorneys review it, let us review the request, and understand that unfortunately right now, this is an area of the law that favors more the individual making the accommodation than the association. Now, the state of Florida in the last legislative session in 2020 did pass an amendment which attempted to strengthen or make it a little bit more stringent on these types of requests to give power to associations. But even then, it's nowhere near to where most associations would like to be. So you're still limited in what you can request. You're still limited in how much information or how often you can request it. And more importantly, I know Barbara had mentioned, her and I had been speaking about this, there's certain things that you cannot do. So let's assume you have to, your attorneys tell you the information that they're providing is sufficient and you must, accommodate the request. That does not mean you can charge a pet fee. There can be no requirements to to providing that request for accommodation. There can be no requirement of a pet fee or a pet deposit or anything like that. Now, it doesn't mean that the owner of the emotional support animal or assistance animal, which is the right terminology for both, is not responsible to make sure that the pet is not a nuisance. They're responsible to obviously pick up after the assistance animal. They're responsible to make sure that the animal is not aggressive or a danger to anyone else. But the association cannot require a fee from that owner for maintaining that pet, nor can it require that the pet walk around with a special tag or a special vest or a special anything. So this is a very delicate area. Barbara, I know you had told me this is an issue that you deal with day in and day out.
Yes, and one of the other things is how much documents. You mentioned documents, what homeowners are allowed to supply to us or us request from the homeowners. And I never feel comfortable even asking for medical documents. I just ask for the service ID and that's sufficient for us because that's should be enough.
Well, I'm glad you mentioned that. Okay. Both in the state and federal level, and I know this, but I'm just going to take a few minutes to discuss this. Both at the state and federal level, those vests that dogs wear, or the little certificates or the little ID that you can get online for your dog, they're not sufficient to establish the need. That is both at the federal and state level. Now, in order for someone to make a request, they need to establish certain things, and it's called the nexus. They have to establish, but what I mean by establish, it does not mean they have to hand over the medical records. They just need to provide you with something stating that they are disabled, either physically or mentally, that the disability affects one of their major life functions, such as sleeping, eating, socializing, walking, anything basically is one of the major life functions, that the animal will assist the individual in performing those major life functions that are affected by this disability, and that without that assistance animal, they would not have the same use and enjoyment of the dwelling as everyone else. So that's the nexus. That's the 4-step process, more or less, simplified version, of course, for today's conversation, but that's basically what they have to provide. Now, the kicker is that this information can be provided by anyone. I recently had one where it was provided by a pharmacist, and my board was really upset that they had to accept it from a pharmacist, but both in the state of Florida and under federal law, in the state of Florida, pharmacist is licensed as a health provider. and it's sufficient. And under federal law, it's even less stringent. It can be anybody with any knowledge of the person's disability. So again, this is a very technical aspect. I could probably do a seminar on pet restrictions on its own, and it'll be hours and hours and hours. But if I could tell you anything, just be careful with these requests. Make sure that your attorneys are assisting you with these types of requests and giving you some guidance as to how to address them. Okay. Next one, selective enforcement. I saw some of your questions, and I think some of them dealt with this. Absolutely no association nor board member should ever engage in selective enforcement. The rules and regulations of the association, the covenants, the restrictions have to be applied across the board equally. Everybody must be treated equally. So what you enforce against one, you must enforce against all. And this is in every aspect of the association, whether it's architectural guidelines, whether it's rules and regulations with regard to how often you can take out your trash, to where, the waiver of late fees for late payments. Everything must be equally applied in order to avoid as much as possible the potential for liability on both the association and the board members individually. I know this is something, Barbara, that you see, I'm sure, a lot too.
A lot. One of the biggest things that we discourage is, especially from a management standpoint, is when we have board members that want to come along on an inspection of the property for violations, because we don't want, and we say, it's a little bit funny, but we want to make sure that the rules are evenly distributed. We don't know who's behind the closed doors. We just see the house number based on your rules and regulations. So you can't say yes for this person and no for the other.
Right. You have to, and especially, which is something that I unfortunately see oftentimes, it especially cannot be that the members are being sent violation letters, let's say, for example, because the roof is dirty, but the more board members are not. That is a huge bullseye on any board member when owners are saying that they're getting cited for certain violations and board members are not. So it's very important that, again, every rule and regulation be applied across the board, board members, residents, members alike. Okay. Misuse of funds. To me, this is a no-brainer. Obviously, I'm not, for those of you that are working condos or board members of a condo, you all know that in the last couple of legislative sessions, there were a lot of laws passed, which to me are what I deem as common sense laws, which have basically stated that embezzling or misusing of funds or stealing of funds is a crime. We would have thought that this was all common knowledge, but apparently it had to be put in the legislature. And that board members have to be very careful as how association funds are used. But it doesn't only have to be crime. It doesn't have to only be theft, embezzlement, or anything like that. Sometimes the misuse of funds come from using funds for other than proper common expenses. So it has nothing to do with theft. It has nothing to do with embezzlement, but the associations deciding to use money for things that are not proper common expense. So these are the things that associations have to be careful. They have to have their attorneys review their documents, review their budget, and make sure that they're using the fund association, which, as we all know, is money from the owners, for proper purposes. Assessments are only to be used for common expenses, nothing else. So for example, and I'm going to give you a ridiculous example, because let's assume now we all decide, an association decides, you know what, it would be kind of nice if we bought an association Ferrari that we could all take turns using. That's a misuse of funds. That's not a proper common expense. Or, I think it would be, great if we, added a wing to the building, because it would be nice. You have to be careful how you use the funds of the association. Make sure that it's something that it's in the best interest of all of the community as a whole, and that it's something that would be deemed a common expense of the association. That term, common expense, is defined in both the Homeowners and Condo Act, but more importantly, it's also defined in the governing documents for each association. So each association may have a a little different interpretation or definition of what the common expenses are for that association. So it's important that that be reviewed and before, excessive amounts of money are used for something that may be questionable. Do you see this a lot, Barbara?
Yes. A lot of the questions that I get from some of my boards is, could we provide food and drinks during board meetings? Wouldn't that be considered a misuse of funds?
That is one that is tricky. I have some documents, and when I say I mean some of my clients have in their governing documents provision that do enable them to spend money for what's deemed social events or whatnot. And I have others that do not. It really depends. But yes, let's assume you have a set of documents that's devoid of any language that would lend someone to the conclusion that social events are part of common, it can be part of the common expenses. Then yes, the use of those funds for those types of events can be called into question. Okay.
About if they were to use funds for, let's say that something has a very pertinent liability, like a sidewalk trip hazard. And they decided, instead of fixing the sidewalk, they decided to do another project in the community. Would that also be considered if it's not something that was necessary at the time?
Well, that's not necessarily a misuse of funds. A misuse of funds, that terminology that we put in here is more using the funds for purposes that are not proper under the Condo Act or the Homeowners Act or the governing documents of the association. The example you provide is probably one where it's not the wisest choice to make when you have a trip hazard, which can result in thousands of dollars of liability for the association versus a project that, perhaps could wait a couple of months. That's just more of are you operating the association in a rational and reasonable way versus a misuse of funds. The next one, election disputes. This can be for some associations, unfortunately, at one point or another, election disputes are a real issue. In the Condominium Act, again, there were legislative amendments passed where they criminalized the forgery of ballots, the forgery of voting certificates, or tampering with any aspect of an election. The Homeowners Association Act hasn't caught up with that legislative provision, but still, any type of election dispute, any type of attempt to tamper with election disputes, with elections, or to sway elections, or things like that, it is something that exposes the association and board members to a lawsuit. Again, we have to go back to the first slide. I don't want to scare anybody, but the truth is that in the United States, anybody can be sued for anything at any time. These are just some of the common things that we see as triggering those situations where board members are being sued. Document inspection related disputes, same thing. In the Condominium Act, it's been criminalized for board members or associations to deny access to records or to destroy records in an attempt to cover up some sort of other wrongdoing. It was, I'm sure you've all read in the news years back of associations that were preventing access to records or destroying records because they didn't want owners to realize that the monies had been not used for proper purposes, some money had been embezzled and whatnot. That is a crime. But even if it's not for purposes, nefarious purposes, such as, covering up a crime, owners in both the Homeowners Act and the Condo Act have a right to inspect the association's official records. There's a time frame by which the association must provide those records for inspection and copying, and failure to do so does expose the association, to potential liability. We all have those homeowners, our unit owners, who like to bombard associations with continuous official records requests. For those situations, our recommendations is always that associations adopt rules and regulations as allowed under the administrative code and the respective legislative statutes for these types of requests to sort of curtail them a little bit, but understand that those rules and regulations are never going to prohibit an owner from making multiple requests. It's just going to establish, a maximum amount. They could do it in a certain period of time, but owners will always have the right to request official records of the association and to be entitled to inspect them and to copy them. That's never going to change. Harassment. discrimination. Discrimination is one that can come up in many ways. Discrimination can come up in denials of a request for accommodations for emotional support animals or assistance animals, like I said before. So that's tied to the pet restriction one. Discrimination in the terms of refusing or disapproving a lease or a sale based on discriminatory reasons. So you all know HUD has issued a memo with regard to reasons why associations may be able, assuming that they have the right to approve leases, reasons that may be deemed reasonable for the denial of those reasons of that listing. So one of the questions that I get a lot is, I have someone who wants to rent. We have their background check here, and the person was arrested 5 times, and we want to deny them. So the first thing I ask and I evaluate is, was the person convicted? If the person was never convicted, under the HUD guidelines, it's not sufficient for a denial. Second is, if they were convicted of what? Was it a felony conviction or a misdemeanor conviction? If it's not a felony conviction, if it's a misdemeanor conviction, it may not be sufficient for the association to have reasonable grounds to deny. The other thing is, how long has the crime occur? So for example, if you have someone that 15 years ago was, yes, arrested several times and perhaps even convicted of a felony, but it's been 15 years, let's say, just to throw out a number, and that person, for all intents and purposes, on paper has been a model citizen, the association may not have reasonable grounds in that situation to deny that person, because it appears, on paper at least, we don't know, that person has been a model citizen for the last 15 years. So this is another area where I strongly urge board members that before they deny someone for a lease, or for those associations that even have sales approval rights, that they always consult with their attorney just to make sure that they're exercising their rights to disapprove on a reasonable basis and not on a basis that can be deemed discriminatory. I'm going to go back to harassment. That's one that, to me, it's a little, I don't know, Barbara, if you have seen any situations of harassment. To me, that's so subjective. What could be deemed harassment?
I think that goes hand in hand with selective enforcement, where,
yeah,
it selectively try to enforce something on one person and not the rest of the community. So, but on the discrimination, I know that, and we've worked on this before together, Gotti, is putting together guidelines for communities. That way, don't leave anything left for the ifs and whats. You could narrow it down and say, hey, this is what we feel is a good guideline for us to approve or disapprove a lease if they have it in their documents.
Correct, right. The most important thing is, like you just said, the first step is, do you even have the right to disapprove or approve? You'd be surprised how many times new clients have come and said, oh no, because we have a right to approve. And I look at their documents and I say, no, you don't. Oh, but what do you mean? It's not in your documents. It must be in your governing documents. It must be in your declaration, the power, that's to begin with. And harassment, like you said, yes, I agree. I think it goes hand in hand oftentimes with the selective enforcement issue, where, certain behavior towards specific members can cross the line and become harassment of that. So it's something that, again, along with management, board members should be very careful as to how they handle those situations. Now, on the next slide, we're going to talk about, what does this mean for board members? Does this mean that we should all stop being board members? And the answer is no. We need you. Every association needs you. Without board members volunteering their time, community associations would not be able to function. And the value of your homes would basically plummet, because there is no one else that would be able to operate the association. So what can protect you as board members from these potential pitfalls? Well, there's something called the Business Judgement Rule. I'm sure you've all heard it. The Business Judgement Rule is a standard that was created to determine if a director of a corporation, in this case, let's say an association, which you all know, you are nonprofit corporations, have breached their fiduciary duty to the stockholders, in this case, to the members, to the owners. For the Business Judgement Rule to apply as a shield against personal liability for board members, directors must have performed their duties in good faith, They must perform those duties with the care that an ordinary and prudent person in a like position would have exercised under similar circumstances. And they must perform those duties in a manner that directors reasonably believe to be in the best interest of the corporation. Now, the important word there is reasonably. Okay, I oftentimes get board members who have very strong opinions and beliefs, and they feel that things should be done a certain way, but it may not be a reasonable way to look at things. Reasonableness is the standard that is determined by what a majority of the individuals would deem reasonable. What I may deem reasonable may not be what Barbara deems reasonable. So it's got to be a more broad view. So this is where I oftentimes have very lengthy conversations with my directors, and I try to guide them to understand what I may deem reasonable may not be what the rest deem reasonable. So it's important that when you are addressing a situation, you keep in mind that you have to do what's in the best interest of all, and taking the whole as the guiding light in that decision making. Now, the business judgment rule, which, like I said, is a shield against personal liability for board members, is very difficult to overcome in court. In other words, it's very difficult to breach that shield to be able to hold board members personally liable. But just because it's very difficult doesn't mean it's impossible. It can happen. And so in the next, we're going to start talking about what is fiduciary duty and how that shield can be breached, where now board members can be unfortunately exposed to personal liability. So one of the first things that board members know, and I'm sure you all realize this, is that you all have a fiduciary responsibility to the members. You owe a duty to those members. And your fiduciary duty as board members to the owners as a whole is divided into three components. You have a duty of loyalty, you have a duty of care, and you have a duty to act within the scope of your authority. Loyalty is what we were saying. You must act what's in the best interest of the community as a whole, not of a few, of a whole. You have a duty of care. You must make sure that your actions are those, are meant to protect the community as a whole. Like Barbara was saying, making sure the maintenance is being adhered to, that you're paying your vendors, you are properly insuring the building, you are taking all the steps that by law or your governing documents you're being required to do, and that you're acting within the scope of authority. This is a big one. Your governing documents will give you certain powers, but will also restrict some of those powers. The laws, both the Condominium Act and the Homeowners Act, do so as well. It is important that board members understand that, and understand that if you go beyond the scope of authority, that you are exposing yourself to personal liability. Things like, let's assume your documents require a membership vote for obtaining a loan. You have to get the membership vote. Let's assume, a big one is material alterations for condos. This is a big one for condos. The statute provides that if your documents are silent as to how you can provide or perform material alterations, then it requires 75% approval of the owners to perform material alterations. If your documents provide for another mechanism, then you follow the mechanism in your documents. Material alterations is basically, unfortunately, anything that can change the look, the aesthetics, the feel, the use of an area. If you're changing the color of a building, that's a material alteration. And depending on the statute and your documents, you may be required to seek the approval of the owners before doing so. There's a lot of other areas that limit the board's power by saying, you can do this if you get X amount of approval from the owners. And that's a scope of authority that you all have to stay close to and review and make sure you adhere to it. Because if you go beyond that, or if you breach that, then you're exposing yourselves. So this is, again, where association attorneys can guide you into determining what kind of powers the board has and to what extent those powers may be exercised.
You mentioned a lot about board as a whole, but shouldn't we also talk about individual board members and their ability to take action on behalf of the board? one person making a decision for the entire board and the entire community?
Well, I always tell my association, and I know that this is unfortunately a practice because board members are volunteers. They should not be getting paid for this. And they have their own busy lives. And I think sometimes shortcuts are taken. But the truth of the matter is that under Homeowners Act and the Condominium Act, decisions of the board are to be made at a duly noticed board meeting. And then no decision shall be made by one single board member. It doesn't matter if you're the president, the vice president, the treasurer, or the secretary. That doesn't give you any greater power or vote over any of the directors. At the end of the day, each director has one vote. They may have other obligations or officer duties as the president, vice president, treasurer, or secretary, but in terms of decision-making, they each have one vote each. The decision should always be made at a duly noticed board meeting where there's a quorum of the board. And it should never be that there's one director who's basically running the show and making decisions for the entire community, because not only is that person exposing themselves to liability, but obviously they're also exposing the association to liability. And to those board members who are not exercising their rights or not limiting that person's control may also be exposing themselves to liability because they're breaching their fiduciary duty. They're not doing what they're supposed to be doing, which is protecting the interests of the whole. So the best advice I give is that for board members to work as board members. That's why it's a board. That decisions be made at duly noticed board meetings, where there's a quorum, and that while certain responsibilities may certainly be delegated to a specific officer like the president, that those delegations of powers be decided at a board meeting and issued in a resolution. So for example, I have some board members, some boards have decided, in order for us not to have come back and forth, we want to give the president carte blanche to sign any contract that is less than $1,000. Let's say this is just an example, everyone. That is something that would have to be decided by the board at a duly noticed board meeting and should be placed in the meeting minutes. That president has been now delegated the authority to address issues without the need of going back to the board that are of less than a certain dollar amount. You have to create parameters. You cannot just give carte blanche to any single individual, because the decisions are supposed to be being made by the board as a whole. That's how you protect yourselves as a whole. Okay. So the next slide now that we've touched on fiduciary responsibility is, okay, so we talked about the business judgment rule and how that basically serves as a shield to protect you all, board members, from personal liability. But when is that shield penetrable? When can that shield be pierced? If you engage in fraudulent or malicious behavior. If you take advantage of the benefits that are not offered to non-board members. For example, I'm on the board, I get a 20% cut on my assessments because I'm on the board. That's a big problem. If they were negligent in their duties, again, failure to act. Once you sit on the board, you have, the fiduciary responsibility to act in the best interest of the community, your loyalty to those members, and you have a duty of care to those members. If you fail to adhere to that fiduciary responsibility, then you're being negligent in your duties, and you may be exposing yourself to personal liability, the potential of piercing the business judgment rule and that shield that would protect you. If they put their personal interests above the associations, again, board members who are given permission to build additional structures or to have additional perks that the rest are not. These are the big ones where board members will find themselves being held personally liable, or at least sued for personal liability because of these actions. Barbara, is this something that you've seen? I have a lot of, unfortunately, horror stories that I try not to share, but do you have any?
I am lucky that I have not had any.
Good. It's always good to hear that. I've been doing this for too long, so I have plenty of horror stories. But it's to me, it really is common sense. It is common sense that when you sit on a board, you're there as a servant for the rest. You're there to protect everyone else. You're there to adhere to what's the common interest of, of the community as a whole. Once you start thinking of this would be good for me, now you're getting into very dangerous territory. Or it would be good for me, or for a relative, or for a family member who lives here, or for, my cousin who happens to have a landscaping company and let me give him that contract. You have to be very careful on how you address these types of issues. And always, so long as you exercise your duties in a way that is with the good of the whole in mind, you're probably pretty safe. And of course, the obvious, stay away from fraud, stay away from malicious behavior, stay away from theft, stay away from embezzlement. The standards, the ones I call common sense, you should be fine. Most board members are fine. And in my experience, most members are extremely honorable people who just want to help their neighbors, who care about their homes, who want to make sure that their buildings or their homeowners associations are being taken care of. It's the value of their home, they're protecting their asset, and they're honorable people who are giving up a lot of their time for free for the good of all. That's been really my experience in the majority. The majority, that's really what they want to do. But if there's any question, and now on the next slide, if there's any question as to what steps you all can take to sort of protect yourselves legally, even further, aside from, obviously not committing these issues that are committing these acts that could expose you to liability, it's obviously insurance, making sure you have proper director and officers insurance on top of your general liability policy. Make sure that you have, that you consider adding crime and fidelity insurance coverage. Now, under both the Condo Act and the Homeowners Act, associations are required to have fidelity bonding. That is a statutory requirement now. It is my understanding that you sort of can have both. I'll leave you to discuss this with your agents. My understanding is that crime and fidelity insurance kind of can give you an extra tier of protection to like cyber crimes and fraudulent checks and wire transfer fraud and things like that, that perhaps fidelity bonding does not. But I've also heard that it depends on the fidelity bond that you have as an association. So these are things that I recommend that you discuss with your agent, or that your manager discuss with your agent, so you have a better understanding. But again, it's just about having a layer of protections through insurance. And then the bottom line, which I'm sure many think it's self-serving because I am an attorney, but there's an attorney here in our office, and Barbara knows her well, who her famous phrase is, pay me now, pay me later. The best advice I can give associations is, if there's ever a question, talk to your attorneys, seek their counsel. When in doubt, seek their counsel. And this is true of any expert, whether it's an architect or an engineer, seek their advice. Management can do a lot, but managers are not attorneys. Managers actually are prohibited by law from interpreting legal documents and from issuing legal opinions. So I know a lot of associations oftentimes put managers in a very difficult situation where they're being asked to issue an opinion on as to what the board should do, when in reality that manager may tell you based on their experience, but they cannot give you a legal response based on the law or your governing documents, because their license does not allow them or permit them to do so. That is deemed the unlawful practice of law. So they can tell you what their experience is, but they cannot give you a conclusive response or guidance as to what to do. So when in doubt, it's always best to go to the experts, your attorneys, your engineers, your architects, to guide you, to help you, give you those opinions. So at least you add an extra layer of protection to avoid liability for any decisions that you may make. And then bottom line, Barbara, what is it? Think before you act. When in doubt, consult your attorney. Best advice that we can give. Now with that, I hope this has been, instructive. I hope you've enjoyed this. There's a lot more. We could have made this into hours and hours and hours, Barbara's and I, given our years of experience, but obviously this is a condensed version. And now I'm not sure how much time we have, Stephanie, but if you want to give us some questions.
Sure, we have about 15 minutes left. just want to let the participants know this is the end of the webinar officially. So if you do not want to stay as part of the Q&A session, you don't have to stay. I'm going to address a couple of questions that we've received when people were registering. This session is not for CEU credit. We did not advertise it as such, and so we will not be giving property managers any credit for attending this course. This is just for educational purposes. So with that, I'll start with my first question that we received. And a board member is asking if they're new to the board, can they be sued for the negligence of an old board member?
Okay, that's it's a little bit complicated and sometimes not. My gut reaction is no. Normally, the acts follow the board members. So in other words, prior board members would still be held liable for their prior actions. Most governing documents have indemnification provisions. Your declaration, your bylaws, or your articles normally have specific indemnification provisions that serve to indemnify directors when they are sued. Obviously, those indemnification provisions, depending on the documents, may be voided if the acts were willful or criminal in nature, okay? But to answer your question, you should not be held liable for the acts of others unless you continue to act in the same fashion as those board members did. So if those board members were doing something incorrectly or something that was against the governing documents or the home, or the respective legislature, then it's important that as a new board member, that behavior be ceased in order to prevent your exposure to liability.
Great, thank you, Carrie, for that. And just to quickly mention, we have about 13 minutes left. We started at 10 a.m. sharp, so we're gonna get to as many questions as possible. I see that questions keep rolling in. We're answering both questions that are being received now and questions that were submitted in advance. A lot of questions have already been answered throughout the presentation. And I've also received a lot of questions that are very specific. We're trying to really tackle the general questions. If it's something specific to your association or your situation, it may require a more detailed legal analysis. So we may skip your question. And if we do that, we apologize. We just can't answer it on a general type of basis. So the next question, Carrie, is can people who serve on committees also be sued?
Yes. The answer is yes. And the answer is that once you are nominated or appointed to a committee, management should immediately contact the insurance agent and make sure that those committee members can be added to the director and officers insurance coverage, just to protect you. My understanding is that they normally are. That has been my experience. The only reason I state this little caveat is because some policies are different. I've noticed lately, especially during the pandemic, and some have some exclusions. So it's very important that be addressed with your insurance agent to ensure that that committee members are being covered under those D&O policies as well.
Speaking of insurance, we received a question from a participant asking if they can sue a resident who has sued the board, and then it kind of increased their premiums, their D&O insurance premiums. They're asking if they can sue that resident for suing them, essentially.
Well, the answer to that, I mean, again, without knowing the specifics, in general terms, the answer would have to be no, because like I said, we have a right to sue, and unfortunately to be sued. And the increase, unless it's deemed that the lawsuit was fraudulent, unless there's more there that would give the association a cause of action against that resident, I do not see how an association can sue a resident for a lawsuit. I'm not sure what the disposition of the lawsuit was, and then sue them for the resulting damage, which was an increase in the insurance coverage. Unfortunately, that's something that's going to happen in our industry whenever there's a claim issued on any policy.
Great. The next question is, what is someone's personal liability? And is one board member personally liable more than another?
No. Well, okay. If they're doing things right, no. Meaning if they're acting as a board as a whole, and decisions are being made by the board, like we were discussing, Barbara and I, then the liability should be the same because they're acting in a united front. If you have a rogue director who takes it upon themselves to make decisions outside of a board meeting, to take action outside of a board meeting and just do things on their own just because they're directors, then yes, unfortunately, that person may be exposing themselves to a higher level of liability because they may be acting outside their scope of their authority, which, as you recall in the PowerPoint, is one of the issues that may unfortunately breach fiduciary responsibility and therefore also assist in breaching the shield of the business judgment rule.
Great. The next question is, if there's an owner that consistently violates a reasonable rule and the board requests compliance several times, would this be considered harassment?
No, so long as there are no similarly situated other residents who are committing the same type of violations. So if everybody's getting treated the same, if everybody's getting the same number of notices, and if they fail to comply, you all are treating them the same, then no, it's not harassment. Now, the most important thing is that the association have proper documentation to evidence that, in fact, that resident in question is, in fact, committing the violation and failing to cure the violation after notice. That's where documentation is imperative. Incident reports, complaints from residents, things that could substantiate the association's reasons for continuously issuing those violations.
Is there a problem with a board of director not taking action due to fear of getting sued?
Yes. Action as well as inaction can be an issue because, like we said, board members have a fiduciary responsibility to act in the good of the whole. They have a duty of care, a duty of loyalty, and a duty to act within the scope of their authority. So if you're not doing anything, if you're letting things just occur and not taking any action, that inaction can be exposing you to liability. So if things have to be done in the community to avoid, maintenance issues, and you're failing to do it because you're afraid, now you may be sued for failure to act and failure to take maintenance, the certain maintenance obligations that you were required to take as board members. So yes, that's a tricky one.
The following question is very timely to what's happening now in the world. Someone's asking if board members can be potentially liable for decisions that are related to the pandemic.
Okay, this is one obviously that we've been dealing with now, gosh, for a year and a half, and hopefully for not much longer, right? Fingers crossed, everyone. But there's not much board members can do. Board members are not medical professionals. I mean, aside from you being that in your personal lives, I'm talking about as board members. The most board members can do is follow the guidelines of the CDC, follow the guidelines of the Florida Department of Health, follow the guidelines of the local governments with regard to what is being recommended. The county has issued new opening guidelines with regard to how to use your pools, how to open pools, how to use your wellness center. The CDC has issued a plethora of information with regard to signage that you must have, with regard to imploring people to maintain social distancing, to wear facial coverings. There have been guidelines with regard to the sanitation regime that association must adhere to or should adhere to. So long as you're following that, you should be okay. The other thing is, I still have not heard of any way to conclusively determine where someone contracted COVID-19. So I just don't see how anybody's ever going to be able to say, I'm suing my association because I got COVID. How they would be able to prove that they got it in the lobby of the building versus in the supermarket that they just went to, I just can't see them doing it. So the most the associations can do is make sure that they're following all the guidelines. And there's a plenty of them, unfortunately, from the county. If you happen to be a municipality like City of Doral or City of Miami Beach or City of Coral Gables or Aventura, those even have an extra layer sometimes of guidelines that you follow all the CDC guidelines with regard to the signs that are to be posted and the guidance that should be, provided to the owners with regard to wearing of masks and social distancing and whatnot. Make sure that your maintenance staff is properly sanitizing all the high touch areas as often as possible, and that you have all these procedures in place in writing and that they're being followed. I think that's as much as you all can do. Unfortunately, you all don't have any magical powers to keep COVID away from your buildings. All you could do is follow what the government is telling you to do and the health officials.
Great, thank you. Next question is, can a board change rental requirements, such as not allowing homes to be rented anymore in their community?
Well, normally that would require an amendment to your documents, okay? Now, a little caveat, for homeowners association, there may be, just an amendment to their documents. Oftentimes, 99% of the times, it would require owner approval. I do have some set of documents that can be amended by 100% approval of the board, but those are much older set of documents, and those are very rare. But that's something that you have to discuss with your attorney. But for condos, I have to caution you that there is a legislative provision that says that leasing restriction amendments that seek to curtail the ability to lease or to establish a maximum or minimum amount of time that units can be leased will only apply to those owners who vote in favor of the amendment or owners who buy the unit after the amendment has been recorded into the public records. That's for condos. That is a specific provision in the Condominium Act that seeks to limit the applicability of leasing restriction amendments to those owners that vote in favor of it or those owners that buy into the building after the amendment has been recorded. So that's something that you all should keep in mind, condos, if you are thinking of amending your documents.
If there is somebody who confessed to being a felon, committing insurance fraud, and was never convicted, can they run and be eligible to run for the board?
Yes. If they were never convicted, then there's no conviction. There's nothing that can be done. They need to be convicted.
Can the association use funds to purchase iPads and laptops that are being used for the community, or is that considered a misuse of funds?
Well, it depends what they mean by using by the community. So for example, if they have on-site staff and they're buying it in purposes of on-site staff, management staff, janitorial staff to perform their duties, that may be something that may be deemed a proper common expense. Again, it would have to be reviewed in conjunction with their documents and what their documents define as a common expense. Now, if we're buying iPads for all the directors, that may be a little bit more questionable. So it really depends who's buying the iPads, for whom, for what purpose, and again, a reading of their documents to determine what's the definition of common expense within their governing documents. Normally in their declaration. When I say governing documents, just point of clarification, I'm referring to your declaration, which is the paramount document in the terms of the hierarchy of your documents. Then it's the articles of incorporation, and then it's the bylaws. The declaration is the one normally which will define what is a proper common expense for your particular association.
Okay, we're going to tackle 3 more questions so that we could keep it in the 1-hour time slot. Someone is asking if underfunding reserves is considered a misuse of funds.
It may not be deemed a misuse of funds, but it's clearly a violation of the statute because the statute requires you to have fully funded reserves. It requires you to have, determine what the useful life of the components that you're supposed to reserve for. So you know whether you are adequately funding that reserve. And if you're not adequately funding the reserve, if you're doing less than fully funded reserves, then that has to be approved by the owners at a duly noticed board meeting. So that is something that could definitely expose the association to some potential claims because that is a statutory requirement and often a requirement within your documents as well. And I'm referring to the condos. HOAs is a little bit more complicated. The HOA question gets a lot more complicated because and to make it short and sweet, it depends if the reserves were established by the developer at the inception, if it was carried over by the developer into your budget, and therefore they're deemed developer established reserves, which would have to be funded, or if they're reserves that are required under your governing documents. So for example, I have some HOA documents that require that so that the HOA have reserves for the roofing system because they're responsible for the roofs of the homes. So for HOAs, it's a more complicated analysis because you have to look at the history in terms of the developer, whether they establish reserves or not. You also have to look at their documents and whatnot. But for condos, the statute is clear. You must adopt fully funded reserves with every annual budget unless there's a vote of the owners to partially waive the reserves or fully waive the reserves.
Thank you. The next question is, can an association issue selective special assessments to less than all the members?
In a condominium, I would have to say the answer is no. Now, there is a caveat to that in the sense that there are some documents that provide that for certain limited common areas that are for the sole and exclusive use of certain owners or owner, that you may be able to assess that owner for the maintenance of that particular limit common element. But again, that is an extremely fact-sensitive analysis that would have to be reviewed in terms of your documents. But so the general answer is going to be no, with the caveat that there may be some situations given the structure of your building that enable you to do so because of certain limited common areas. But again, that's fact sensitive to your condos. And in HOAs, similar caveat. There are many HOAs that enable associations to do what's called individual assessments, depending on, for example, you're responsible to mow your lawn. The documents provide that I have to give you 30 days warning for you to mow your lawn. And if you don't do so, the association can go in and mow it for you. And the cost and expense of that service will be assessed to you as an individual assessment. But again, I want to make it clear, this is a fact-sensitive analysis that is based on a review of your documents. And of course, the corresponding law, whether it's a condo or an HOA.
And the final question we're going to take during the session is crime and fidelity insurance required under 718? And if you could answer under the HOA statute also for those who are attending that are.
Yeah, that's a great question. So like I said, under both the HOA and the Condo Act, so under 720 and 718 and 720, you are required to have fidelity bond. Now, and this is why I recommend that you speak to your agents. I've gone mixed information from several agents. Some agents find it to be the same. Some agents find the fidelity bond and crime and fidelity insurance are one and the same. And I have others that say, well, it really depends on what level of fidelity bond you carry. And you may be able to add additional coverages by having an additional crime and fidelity insurance. But under the statute for both 718 and 720, what's required is fidelity bond that covers, and they must cover the total amount of funds that the association is going to have access to. And it must cover anybody who's going to be having access to those funds, as well as the president, vice president, and secretary and treasurer. And that's for both the condo and the HOA.
Thank you so much, Carrie and Barbara. We are definitely going to be offering webinars throughout the year, so make sure you subscribe to our mailing list and to Vesta's mailing list. We'll be collaborating in the future. Thank you so much for your time to both panelists and to all the participants that attended. As a reminder, we will be emailing participants this presentation, and the recording will be available on our YouTube channel. Any closing thoughts, Carrie and Barbara?
No, I just want to thank everyone for joining us this Thursday morning. I hope we provided you with some information. I know it was in a very condensed format. We will be working on creating some additional seminars that expand on some of these topics, but we hope that at least you found it to be informational. Thank you so much for attending.
Thank you, everybody. We really do appreciate you attending.
Thank you all. Bye-bye.
Bye-bye.